Hi, this is Mark Wallstrom. You're watching Speaking of Settlements, a featured broadcast on the Legal Broadcast Network. Well, today I'm discussing an article in the Wall Street Journal, today being March 19th, 2012, and the title of it is Annuity Case Chills Insurance Agents. Now, it was written by Leslie Schism, who's a staff reporter for the Wall Street Journal. Excellent article, and this story has been making the rounds in the insurance community and in the financial press. But what it is, and it discusses, is the case of an annuity agent in California named Glenn Neeson, who sold an indexed annuity to an elderly woman. And as many people know, there's been questions, issues, concerns at times with the sales practices of people selling equity indexed annuities. And we can address some of that at a later time. But what made this case particularly notable and chilling to a lot of agents, which I think is going to have tremendous application to structured settlement agents as well, is the fact that this agent was prosecuted criminally under a California statute that makes it a crime to sell an insurance or financial product to a senior at a time when they're vulnerable or don't understand it. Now, we're going to be having some follow-up commentary on the Legal Broadcast Network in a couple of days with some California judges and people who are familiar with this statute and this law in the state of California and why it was handled this way. But the facts in the case, and we're going to link to it on our article and on our page, was this gentleman sold a $175,000 equity indexed annuity to this woman. She went into a bank with her then boyfriend, who was also a client of the agent and had purchased the annuity agent. She wanted to, and again, this is all, I'm going off court record, I have no firsthand knowledge, but in reading the article, she wanted to get something better than she was getting in her bank return. The agent put her into this annuity product. And shortly thereafter, she exhibited signs of serious dementia. And again, the heart of this is that was she competent? Was she vulnerable at the time of this decision? And was the annuity commission that was going to be paid to the agent of sufficient size to establish criminal intent on his part to essentially steal this money through this transaction by putting her into this particular product? As I said, we're going to have some legal experts on later this week to further discuss how the statute works and the level of what rises to criminal action as opposed to what many people would assume is a regulatory issue or a civil matter regarding the suitability of the investment. But this was written by an established agent who had been around for quite some time, and he is now facing 90 days of jail time. I'm sure, obviously, loss of his license. His business has probably collapsed. And the application in this case, there's some interesting and puzzling questions that we want to get into. One thing I found really interesting was that when they went to the bank to withdraw the funds, this woman and her longtime boyfriend, the bank manager felt that they were confused, or she was confused and didn't really understand what she was doing. And she notified California Senior Protective Services. So there was a referral by the bank to a regulatory agency. Now, I'm assuming this regulatory agency then followed up on the matter, possibly made a criminal referral to the district attorney's office. Or this referral by the bank to these prosecuting agencies, that to me is it's really interesting, something we're going to get more information on, because I don't know if they had an affirmative responsibility to make that referral, if it was something that they did under their own discretion. But it points out that there is an evolving change that is significant for structured settlement people and agents and people who are working with our base clientele, which is many times minor children, people who have suffered tremendous injuries, people who are dealing with chronic pain and may be under the influence or under steady medication with painkillers. people who are under emotional duress, may be suffering post-traumatic stress disorder, may have severe bouts of depression. All of these issues may come into the competency of someone's decision-making process. And while I think most professionals agree we do the best we can to help people make a decision that keeps them safe and keeps their money safe, and many of these people, almost all of them, I would argue, are represented by an attorney or family members at the end of a legal process. The fact is, people are making these decisions oftentimes under duress, sometimes with limited information, and much like other annuity products, the decisions, if not irrevocable, to get out takes substantial surrender charges and penalties in many cases. So, we're going to follow this case very closely. We're going to bring in some additional legal experts, some people who have adjudicated, elder abuse cases in California. And we're also going to start looking at some of the other state laws that have been passed, consumer protection, elder protection laws around the country, to see what other states have these type of regulations where you have elements where, there will be referrals to an attorney general or a state prosecuting attorney, and whether agents can be prosecuted criminally for what have historically been regulatory or civil complaint actions with family members. So again, we don't know enough about the case to weigh in on the facts one way or the other as to whether this was an appropriate verdict or whether it was an appropriate sale or inappropriate. We'll certainly allow the jury and the judge and the people who prosecuted this, we'll stand by their decision on what they did. But what we really want to look into is, again, and this will be kind of an ongoing series we're going to do for the rest of the month, because I think this case has really profound implications for our profession. When the size of a commission can be used to establish criminal intent, as it was in this particular case, what constitutes incapacitation of an annuitant or somebody who's buying something with the help of a competent family member or friend, as happened in this particular case. What is the requirement of other financial fiduciaries and other professionals to affirmatively report to an elder services division in a particular state if they feel someone's being taken advantage of? This has profound implications, I believe, on factoring transactions. If people are getting out of annuities and don't understand it, are they bound by the same regulations and the same reporting requirements that apparently exist on the sale of annuities in California? Interesting questions, important questions for people in our profession. And I think, in the larger issue, it points out something that we're going to be covering for the next few months from a professional practices standpoint, which is the issue of disclosure of compensation for agents, and whether or not the structured settlement profession needs to be focusing more on fee work and hourly work, much as the financial planning profession made that shift in the 80s and 90s toward fee and hourly work. Is that going to be suitable? Is that something that the structured settlement profession should be doing as well on the disclosures of fees and compensation and suitability of compensation, for the products that we sell? So, interesting case. I really suggest you read it. The Wall Street Journal article, again, was March 19th. The reporter is Leslie Schism, S-C-I-S-M. And read the article, check it out, and we're going to be following up with legal experts and seeing where this case takes us in the structured settlement profession. Once again, always a pleasure having the opportunity to talk to you. Check out our websites at Speaking of Settlements and Wallstrom & Associates, the Settlement Channel, and join us again here next week. I'm Mark Wallstrom. Have a good day.